Court on Monday. Carol.
Thank you, Brandis. 40 years ago, the Supreme Court ruled that no public employee could be forced to join a union, but that non-union workers in states including Illinois must pay lesser so-called fair share fees, those fees that compensate for the benefits non-union workers receive from union-negotiated contracts. But a case out of Illinois, backed by Governor Bruce Rauner and conservative donors and activists, aims to do away with fair share fees. It was heard at the U.S. Supreme Court yesterday. Joining us are Jacob Huebert. He is Director of Litigation for the Liberty Justice Center, which represents plaintiff Mark Janus, a child support specialist in Illinois who does not want to pay union fees. Also with us, Anders Lindall. He is Public Affairs Director for the American Federation of State, County, and Municipal Employees, Council 31, the union to which Janus does not want to pay those fees. Welcome both of you back to Chicago tonight. Jacob, I know you were in the Supreme Court yesterday. Paint us a picture of the atmospherics there.
Well, it was a packed room. There were very long lines to get in to hear this argument because there's so much interest in it on both sides. Outside the courtroom, large groups of people on both sides of the issue supporting Mark Janus on the one hand or unions on the other hand. And then inside the courtroom, things went more or less as you'd expect. There were some justices who questioned our side a lot. There were some justices who questioned the other side a lot. And there were some justices who notably didn't say anything. So you can't...
Well, one in particular, Neil Gorsuch, right?
That's true. Justice Gorsuch said nothing. And I don't think you can read anything into that. Now, of course, it's just a matter of seeing what the opinion says when it comes.
Anders, I know you weren't there, but I know you read every word of everything. So what was your sense of whether this is going to be a win or a loss for you?
Well, I don't think anybody could predict which way the justices are going to rule, but I am fully confident that if they rule on the facts and the law and the 40 years of precedent to which you refer, that they will rule on the side of working people. There is a powerful, wealthy elite in this country that has bankrolled this case. It has bankrolled front groups like Jacobs, the Illinois Policy Institute. It's bankrolled politicians like Bruce Rauner, who brought this case. And they want, their stated purpose is to defund unions and to strike a mortal blow to the labor movement. That's because they know that when working people have the freedom to form strong unions, to negotiate together, to speak up for themselves and their communities, we stand in the way of their power and greed.
Jacob, a lot has been written about whether this has been of late a concerted and conservative, highly moneyed effort. Is it?
What it is, it's an effort on our part to represent a man, Mark Janus, who objects to being forced to pay this group that advocates for policies that he objects to.
But this is more than Mark Janus, is it not?
Well, it's true. There are a lot of people on his side. There are a lot of people who showed up at the Supreme Court, people like teachers and other government workers who also felt that their unions didn't represent their values and objected to being forced to give them money just to be allowed to work in a government job. So there's a wide variety of people who support this. And of course, there are donors who support this. But you know how we raise our money is we say what our mission is, and then we solicit donations from people who want to give them voluntarily, which is a sharp contrast from how AFSCME operates, because they have to force people to give them money to do what they want to do. We put the mission out there, and we count on people to support it if they believe in what we're doing.
Anders?
Yeah, I think we should talk about the money behind this case. And there was a very revealing investigative report in the New York Times just on the eve of the case being brought that showed that it's folks like Dick Uihlein, who is a multi-million-dollar donor, the top donor to Jacobs Group, and also a multi-million-dollar donor to Bruce Rauner's campaign. Folks like the Kochs, Rauner himself has given to the Illinois Policy Institute, the Searle Foundation, the Bradley Foundation, just a small group of billionaires who have been funding not only their group, but many other front groups like them around the country. It's very interesting.
But labor isn't poor either. I mean, we would stipulate to that, correct?
We don't hide the sources of our money. We are the result of working people pooling their resources together to use their voice to speak up for themselves, their families, their communities,
Jacob,
and that's who we advocate for.
Are there new facts in this case from this 40-year-old ruling that has stood 4 decades. Are there something changed?
Well, what people have realized over time is that that decision from 40 years ago doesn't really protect workers' First Amendment rights in a couple of ways. One, there's no way to actually hold these unions accountable in how they spend the money. Workers get negligible information about where their money actually goes, so nobody's policing whether this is going to improper political activities or not, even under the standard the Supreme Court set 40 years ago. Another problem is when people are forced to give money, even if it's all going toward the union's bargaining, they're being forced to pay for union political advocacy, because that's what certainly AFSCME does in this state. They advocate for more spending, they advocate for how the government should run its programs, and they advocate for higher taxes. And Mark Janus is forced to pay for all of that.
Anders, the justices, some of them seem to be suggesting that, in fact, everything is political or political speech. The union's response to that is?
Well, I think that only the grossest misrepresentation of what workers do through their union could see it that way. And let me give you 2 very quick examples of what workers do through their union. You know, here in Illinois, AFSCME Council 31 represents child protection workers. Folks who investigate allegations of child abuse and neglect. Recently, there was a woman child protection worker who was on a call to protect a defenseless 2-year-old from his violent, abusive father. She was attacked, and just 2 weeks ago, she died. She was murdered in the line of duty. When child protection workers, through our union, get together to advocate for workplace safety, and to advocate for protecting those kids, that's not politics. And that's the history of our union. 50 years ago this month in Memphis, Tennessee, 2 sanitation workers were crushed to death in the back of a garbage truck. Their fellow sanitation workers went on strike, touched off by that tragedy, and they demanded recognition of their union, AFSCME, safer working conditions, and to be treated with humanity and dignity. Dr. King marched with them. They weren't playing politics. They were standing up for themselves and their community.
To which your side says?
If you're going to tell me that AFSCME isn't political, if you're going to tell the viewers that AFSCME isn't a political organization, I'll just let that stand out there and let people judge that for themselves.
Isn't everything political on this, frankly? I mean, whether it's Dick Uline's money or the Liberty Principles or AFSCME.
The key difference is they are forcing people to give them money for what they do. And the First Amendment is supposed to protect people against being forced to pay for somebody else's politics. And you shouldn't have to give that First Amendment right up just when you give a government job, just because you have a government job. And I want to say something else about the interests of workers. There's a worker in this case. There's one party in this case who's a worker, and it's Mark Janus. And they don't care about him, apparently. They don't care about his interests. They don't care about serving what he considers to be important. And so this is it's not workers on one side and other interests on the other. The worker in this case is the plaintiff who's challenging this law.
Let's talk a little bit about what may or may not happen here. Is it conceivable, are you prepared, either of you, for the fact that whatever the court rules, it will be narrower than broad? Anders?
I think that's a possibility. I certainly know that whatever the court rules, again, you know, if the court looks at the facts, the law, and the precedent, the decision is clear that the precedent will stand and the court will rule for working people. But whatever the court rules, we'll continue to come together to advocate for the public services that we provide.
But it will be a decimating blow if you lose, will it not?
I think that people understand, especially here in Illinois, where working folks have been under attack from Bruce Rauner and his front groups like the Illinois Policy Institute for years. They understand who's really behind this case, they understand what it's really all about, and they understand that we need to stick together. Just like they never quit on their communities, they never quit on each other.
Jacob, just out of curiosity, is Governor Rauner still a part of this as closely as he once was with Liberty?
No, he's not a part of this lawsuit at all. He originally brought a lawsuit in 2015 that he was promptly dismissed from, and he's had absolutely nothing to do with the case since then.
Except he was at the court with you yesterday.
He was not. He was not with us.
You and Pat Hughes and Bruce Rauner all stood together on the steps at a
That
news
is
conference
not true.
afterwards.
I was there. You were not. We did not stand with the governor. You can go ahead and do that. The governor ran out of that courthouse and tried to get himself in front of the cameras before everyone else.
What's the disconnect?
That's what happened. But he was not with us, and he's not involved in this case.
It's political.
So what's the disconnect on that?
We would have been happy if he'd filed an amicus brief supporting us when we were asking the Supreme Court to take this case, or at the merits stage. If he wanted to help us there, that would have been great. But the fact is, he didn't, and he just has nothing to do with it.
If there is a narrower ruling in this case, do you have a prediction of what it might be? I mean, you know what your lawyers are all looking at, right?
You know, it's very interesting. If you look at the amicus briefs in this case, which is just about all there is to go on, because actually there's no factual record. The case wasn't actually tried at the trial court level or the appellate level. It got to the Supreme Court on a motion to dismiss. So if you look at the amicus briefs, there is a panoply of individuals and organizations filing on behalf of working people. We're talking about the mayors of the largest cities in the country, Republican rank-and-file legislators, many Nobel winners, the U.S. Conference of Catholic Bishops. But there is an amicus brief by the Reagan administration's Solicitor General. If we're talking about politics, this is no liberal, lefty. He suggests that there might be a way to find a narrowing, and there was discussion among the justices, principally Justice Breyer and Kagan and others yesterday.
So Jacob, though a lot of people are predicting that given the conservative nature of this court, you are standing the greater chance of being the victor than the loser. But if you lost, what then?
Well, then people like Mark Janus will continue to be forced to pay for union politics that they disagree with.
And let's be clear. Under current law, as you have already elucidated, nobody is forced to join the union, nobody is forced to pay dues, and fair share exists for exactly this reason, so that nobody is forced to pay for politics or lobbying at all. That's the law, and nothing in this case will change that.
What we may be forced to do is wait until June when the Supreme Court finally rules, and then we hope to talk again about this. Thank you very much, Jacob Huebert and Anders